Yes, Miss Kavanagh.
Thank you. Well, my lady, my lords, I ought to have said at the beginning that the father is watching on the live stream with an interpreter.
Good. I'm very pleased to hear that.
It seems to me that having reviewed everything, we in fact have touched upon almost all the points I was going to make, and the rest would only be repetition of the written case upon which I'll ultimately rest. But if perhaps I just deal briefly with one point that I was going to mention, and then just almost in a few lines the Article 33 point, because I think that's been heard and I've done a written analysis, and then just address the position if ultimately the court were to allow the appeal.
Certainly.
Thank you. So just, albeit a point that my lady and my lords will well know, where there is a risk of harm to a child arising out of domestic abuse or criminality, antisocial behaviour, or here the dishonesty and manipulation by the father before the court, and manipulation of the mother, and the fourth respondent, and threats in relation to him, the key issue for the learned judge is to identify how those risks translate to the child, and it's incumbent on the local authority, the appellant, to, in the course of the case, to identify how those risks translate to the child now, not as they were then, and how they would translate in the context of each placement option. I've been through how I say that was looked at by the judge, but the reality is, we say that it therefore is not sufficient to say, because the father doesn't accept findings, that he poses a risk of having of causing harm or violence in and around the child, and because his lack of acceptance wouldn't necessarily in and of itself be a bar to placement here, because of course there are risk assessments done all the time in the family courts in England and Wales, where people, individuals, don't accept serious findings, and what the court's looking for is safety plans with other individuals that can be built around the child to prevent the harm coming to fruition, specific harm in that context. And the grandmother, the uncle in the same household may be part of that. The arrangements that could or could not be put in place, which have already been through by the Italian social services in relation to keeping the adults apart from one another during contact, and in England the same. When contact occurs, and indeed the possibility of any work that could or could not be done, even if it's not central to his accepting of the findings, but to working within a safety plan on the assumption that he poses a risk, and that may be the therapeutic work that could be considered. So there are multiple issues just in that are not sufficient for the local authority to say that the appellant to say that if he doesn't accept the findings, there can be a conclusion that the risk can't be worked with. It can, and it could be here with a local authority, within or without out of care proceedings or in care proceedings. Sometimes there are families that are worked with outside the care proceedings on the assumptions that these things have happened, even if they haven't, they won't accept them. So the same can be assumed in relation to the competent authorities in Italy, that they have a structure of safeguarding and child protection that would allow them to do that. And I won't rehearse that, which I've said, about how that should have been engaged or is to be engaged. Just that the court was entitled to assume, having heard what she had heard, the learned judge, that they had similar approaches to safeguarding in that regard, and a safety plan could be put in place. Now, if I then just turn to the support services from the Italian state very briefly, Article 34 is information in relation to a child's protection to be provided from the contracting state abroad to the state with jurisdiction. And you'll note, as I've already indicated, on the face of the second report, the primary report from Italy, they put that under Article 33 or Article 34. And the court did receive that information along with evidence from the relevant social worker and received a legal advice that had been ordered by the court as to how to place. We respectfully submit that the structure of information and the fact that the judge had paused, having made her findings of fact, having drawn conclusions as to the child's best welfare outcome, and asked for then a transition plan in conjunction with the foreign state was sufficient, having received that information, that Article 33 formal request is not engaged. And I'd only be repeating my learned friend Mr. Sampson Casey's points about there are of course placements all the time under certain orders that don't necessarily bring about engagement of Article 33. That doesn't mean that the lower courts wouldn't benefit from some guidance as to the sorts of steps that ought to be taken. It's plain, and it was done here, that the consular, the consul of the child, who is a national of another country, should be warned where there is care proceedings, and that's clear from the dicta of many authorities in this court. Unless there's some way unsafe for a child, and then there's a guidance by the President in relation to that. But otherwise, the approach of utilising the requests under Article 33 and the for information, which was done here, requests for assessments, we see in relation to Romania that was used constructively by going back with a request for a fuller assessment. The judge was satisfied that what came back was a full assessment in relation to that. So that appears to be an appropriate route, and it's our experience, certainly on the ground, that once you have engaged the relevant local social services department to the child's ultimate placement or parent, the timescales can be fairly fluid. Sometimes they're a matter of weeks, sometimes they're a matter of days. In fact, it's a lot more responsive. It's more likely for assessment that the timescales would be longer. But there is...
Well, we know that from the evidence of the social worker, who basically said it would be a long time.
Yes, however, she was talking about her own availability. Had it
No, she said we're very busy, and it would be longer if it was through the other service.
Yes, so there is, yes. So if there is to be guidance, I propose that actually there needs to be clear responsibility for the sending of the information, absolute clarity as to what is being requested and what is capable of being provided. And so initially, the request ought to be for an assessment, but be clear to ask for a response if the type of assessment described and contemplated is not possible. And in our respectful submission, there ought to be a, at the same time as the request goes, given the timescales for children in these sorts of proceedings, they should automatically be being translated into the relevant language and going in the first instance. One can lose weeks, in fact, waiting, as we had here, for ICACU to come back and say, well, the central authority initially required it all in Italian. That's a common thing that's always requested. It should be done in the first instance, sent in Italian. That can save weeks for the child. So there are a number of things that could be done, and the model that was adopted was not in and of itself, respectfully submit, improper. There was a massive delay in making the request in the first place, and that's because there was a mix-up in the local authority and somebody thought it had been done. But once it was made, the timescales, in fact, were not... well, they were a number of months, but they were not... The first initial report was done fairly quickly. In relation to, then, if I may, the final point of... in the event that the court does not consider that the appeal should be dismissed, and in fact should be allowed either on one or more grounds, the court's then faced, of course, with the choice of substituting my lady and my lord's own view for the evaluation exercise for what the right outcome for this child's long-term placement is to be, or to remit for a welfare decision having not unsettled in any way the findings, for C to be reheard either by the same judge, given the wealth of information or evidence she had, or indeed allocate to the family presider for consideration. We submit that if you're against us on the appeal and it is allowed, the court would naturally be overturning the child arrangements order that was in principle approved by the court. That plainly is the order that provides for the father to have care, even if it's not been enacted, but the principles behind it and the fact the court approved it would be being overturned, and the court's evaluation exercise would be set aside. The child would be under his interim care order, and we respectfully submit that it ought to be remitted to the lower court. Now, whilst I would say, of course, in the initial instance, that ought to go to Her Honour Judge Coppel, I recognise that it may be that the court considers that Judge Coppel had taken, if the court concludes that Judge Coppel had taken a presumptive approach to the case, then I don't pursue that submission. In our respectful submission, it ought to go to the family presider, who would either keep it for themselves or indeed allocate it to another judge. But in our respectful submission, it's for that judge to then hear any applications for how to proceed and to evaluate on the full bundles of evidence before it, over 2,000 pages, whether or not the timescales for the child indeed allow any further assessment at all, or whether it should be listed in short course for a hearing with a bit of updating information and evidence from social worker, guardian, the father, and any assessor of the father, that either the Italian assessor or indeed social worker, if they've done any additional work. It may be that that judge identified, or indeed having heard submissions, identifies that there is, and it is appropriate to send the judgment through to, or the parts of the judgment and findings as to risk through to the Italian authorities and consider whether they ought to undertake any additional assessment work. But even if they don't, it may be that that judge would consider whether or not to ask the Italian authorities to just send more information based on that formulation of...
That would be a matter for the first instance judge.
It
Would be wholly inappropriate for us to start purporting to case manage.
Yes, I'm highlighting that as one area of complexity and nuance that would really require a deep dive into the children's current situation, for the reasons in support of a submission that this is a case that the court ought not to replace the finding, the evaluation, and sit essentially as first instance and identify that the child should remain in care for the remainder of his minority in the care with in the local authority approving their care plan. I mean, that we submit would be inappropriate in this case, just because it is a case in which there is an awful lot of detailed evidence that this court hasn't had available to it. We've had about 10% of the papers from the previous proceedings. My lady, my lords, has I know my learned friend Mr. Sampson indicates that there's overwhelmingly positive evidence supporting the child staying in this jurisdiction in foster care. But the reality is that the learned judge found considerably positive information about why the child should be growing up in his Italian family in Italy. And it's also right to say that there is, if the court's conclusion that the evaluative exercise was flawed because there was a gap in the evidence that was never properly addressed, then that's a matter for the court to consider whether it's necessary to address before coming to a final conclusion, as my lady has already identified. It would be improper for this court to go into that sort of detailed case management at this stage. Just to illustrate this, the guardian in her final submissions to the court, in the lower court, it's at 194 paragraph 20 of the bundle, said that no plan perfectly meets the needs, all the needs of the children. Each involves significant losses and gains for the child, and it's a difficult balance to make, which to some degree, of course, depends on the findings made by the court. But only to some degree. It wasn't entirely, of course, dependent on the findings, because there were significant losses and there was evidence, we respectfully submit, of potential for instability in the foster placement, primary potential, not just from together and apart assessment, which I'll identify in a moment, but also from the conclusions the Guardian reached at the conclusion of the evidence, because her paragraph 19 of the same document identifies that there is potential for instability within the placement. But that's inherent also within long-term foster care. But this is a 6-year-old child, and in the circumstances there are big decisions for his long-term future, in circumstances where his relationship with his father may be, in fact, in some respects, a protective factor for him in stability, whilst there are risk management issues, and indeed that need to be addressed potentially in further assessment if that's the court's conclusion. The child's had a traumatic history and things move on, and even a matter of a few months it's unclear what the updated position is in relation to the placement, his relationships with his brother, how his brother's developing independently. And we note and draw your attention to the together and apart assessment at pages 299 to 300 for some of the real difficulties that could arise in those two boys remaining placed together. So the child judge or judge at first instance in our respectful submission has a special advantage, and it is in our respectful submission an apposite case for the dicta of this court would be island hopping, as opposed to drilling down to an evaluative exercise, which, if the court is permitting the appeal to be allowed, it has identified the importance of that evaluative exercise to be done in the appropriate detail, with the appropriate list of advantages and disadvantages rooted in evidence. And it's at that point that this court would be at a substantial disadvantage undertaking that evaluative exercise for itself. So whilst I recognise the, of course, this court's powers to do so, and the imperative against further delay for the children, it is indeed, if the importance of the evaluative exercise and the manner in which it's being described by those in support of the appeal is to then go forward correctly, it ought to be done in our respectful submission by a judge who has available to them at the very least all of the evidence, including the evidence which supports a placement in Italy, and if necessary to, at the very least, even if not requesting further assessment, to request information under Article 34 of what services might be capable of being provided in Italy under this formulation of risk. So essentially, the finding of facts stage that my lady has identified having take place, sending to Italy the findings and identifying if there are any support services on this formulation of risk that they could provide, if so what, and then potentially, if the court is minded to have further assessment, it could be here, Italy, or a combination of both. It may be none. The court may be satisfied with an update on support services rooted in the findings and an update on information about the children as they are now and their current foster placement, and hear from the father and the professionals. That's a matter for the first instance judge, who would have well in mind the delay imperative for these children. So unless I can assist you further, those are our submissions.
Thank you very much indeed, Mr. Cabinet. Mr. Stoner.
Thank you, lady. Lady, my lords, can I begin by formally adopting the submissions that have been made on behalf of the local authority and the mother, and then address you by reference to our skeleton argument, just highlighting one or two points along the way.
Most helpful, thank you. Should we turn up your skeleton argument then? Yes, thank you.
Lady, we, when making the overarching submission that the learned judge's evaluation was deficient, focus on three particular matters. The first of which is risk of harm, and I appreciate all of these have been touched on already over the course of today. Under risk of harm, could I first of all just respond to the point made on behalf of the father, and it's in paragraph 18 of their skeleton, where reference is made back to the Guardian's report, what was expressed at the time as her final analysis back on the 15th of April of 2023.
I dare say she thought it was.
I dare say so, my lady. And as my lady has already observed, there was significant passage of time, and that was updated by the Guardian in her position statement, which was submitted in December of last year, and the Guardian's position changed dramatically. But even then, looking at the position expressed in April of last year, it was heavily caveated, with the Guardian saying, should there be no matters that arise or findings made that would compromise C's welfare and safety. And of course, matters did arise, findings were made. Lady, the second point under risk of harm is internal page 2 of our skeleton, paragraph 6, and it's point 3. The learned judge, in finding that the risks could be managed by social services in Italy, failed to address meaningfully how management by any social services could be effective given the nature of the risks. And we respectfully agree with the point that my Lord Justice Moylan made earlier in the day. And one of the matters that the learned judge, with respect to her, failed to address, and which needed to be addressed, was the point we make over the page, re K, the decision, rather the judgment of Lord Justice Peter Jackson, whether there was a link between lies, as were found to have been said, and the deceit and manipulation in this case, and welfare. And the learned judge failed, we respectfully submit, to make that link.
When you say failed to consider that link, or failed to, what do you mean by make?
Failed to address in any meaningful way that link. The learned judge did say that the findings, including the findings as to domestic abuse and her findings generally in relation to the father, could ultimately be addressed by social services in Italy. So to that extent, it could be said that the learned judge did make the link, but we respectfully submit that it was not in any way meaningfully addressing that link. My lords, could I move on then to sibling relationship? A, B and C and principal reporter, which I was going to refer to as the Scottish case, but that makes me sound rather superstitious. But in that case, the Supreme Court emphasised the need, on a case-by-case basis, for a bespoke analysis of the sibling relationship, a nuanced rather than generic analysis. Clearly, some cases will require more nuance than others. This is a case where a nuanced analysis really was required, given the facts that are well known to this court. In her submissions earlier in the day, my learned friend Miss Markham referred to some evidence that the Guardian had put before the court that brought that relationship to life. And I wonder maybe if I could just take a moment to take you and your lordships to the Guardian's position statement from December. And that's Appeal Bundle Electronic 307. In fact, it's happily the pagination marries with the hard copy. It's paragraphs 2, 3, and 4. And so in paragraph 2, about a third of the way through, we have a picture of C with his older brother on their tablets, sat together. In paragraph 3, we have C now displaying the dry sense of humour that his older brother is known for. And then in paragraph 4 at the very end, the older brother very protective of his younger brother. The learned judge, with respect to her, does not engage in any sort of nuanced analysis. The furthest that she goes is to refer to the guardian's view as to this being child C's most important relationship, without actually expressing her own view as to whether she agrees with that or not. Could I move then on to our third subheading, the skewed balancing exercise? And my lords, you've already been referred to Re-H. And Re-H, we know from the headnote, involved a 15-month-old child, now a 3-year-old child, who had been with prospective adopters for some 15 months. And the decision in the court below was for the child to be removed and placed with their father. The following year in Re-W, this court was concerned with an appeal concerning a 2-year-old child who was settled again with prospective adopters, and at a late stage in the proceedings, a family option was identified, deemed viable, and ultimately preferred by the judge below. And Lord Justice McFarlane, as he then was, refers back to Re-H and expands upon it. The case itself is at tab 6, but my lady, for present purposes, we hope that the paragraph set out in our skeleton will suffice. But at page 6, internal of our skeleton, paragraph 15, having cited Re-H at some length, the President goes on to refer to submissions that were made by Mr. Fian and as to the placing of the fulcrum in a balancing exercise. And we respectfully submit that here the fulcrum was incorrectly placed by the learned judge. And at paragraph 16, we give some reasons in support of that submission. But if I could just highlight point 2, which has come up a number of times over the course of today, the option of foster care that was a realistic option for C. The learned judge, as my Lord Justice Green observed, addresses it in generic terms but not in detailed or nuanced terms. And to give an example, paragraph 281 of the judgment, which is 113 in the appeal bundle. Paragraph 281, it's about halfway through the paragraph. Considering the pros and cons, not only will the child C face having to remain in foster care, which is perhaps telling when we know that this is in fact a placement that child C has lived in for about a third of his life. He was 4 years, 4 months old when placed with his current carers. And the guardian's position statement, to which I took the court a little while ago on the sibling point, it's 307 in the bundle, paragraph 3 in particular, which includes accounts of child C expressing worries about his foster carer disappearing, words to that effect. And the guardian's own observations of just how child C has come on in that placement, from being a very anxious child who responded fearfully when being in any way challenged about his behaviour, to generally a much more relaxed and happy child. And plainly the foster carer deserves a great deal of credit for that, and it was a feature of this case that the learned judge did not meaningfully engage with. We submit that this foster carer was in it for the long haul. Of course, no guarantees, there never could be, but it was an important feature of this case. In terms of outcome of the appeal, our primary position on behalf of C is that this court can deal with the matter. It does not need to remit it for further hearing. There ought to be a care order in relation to C on the basis that he remains in foster care with his older brother, and the contact arrangements that have been set out in the care plan and touched on over the course of today. Realistically, and it rather goes back to the risk of harm and that re-K point, drawing the link between lies and welfare. In the circumstances of this case, against these very serious findings, with a father who does not accept those findings, realistically, what prospect is there, wherever the assessment is undertaken and by whom, for an outcome other than the one that the local authority were inviting the court to make? So really, that is our primary position. Respectfully, we leave it to the court if you are ultimately minded to allow the appeal. My lady, can I then just touch briefly on the Hague Convention? And Article 33, the question raised in submissions on behalf of the father and the mother as to whether Article 33 encompasses a placement abroad with a parent. Miss Markham took you to the paragraph 13.38 in the practical handbook for the 96 Convention. And in due course, perhaps not necessarily now, I would respectfully invite my lady, my lords, to look at the full content of that paragraph, and keeping in mind the circumstances of this case, very relevant and clearly necessary that there would be full consultation between the authorities here and the authorities in Italy against the background of child C being taken into care and the need for assessment and for supports and services in the event that he were to be placed with his father in Italy. The reference has been made to the most recent revision of the Brussels regulation. Could I respectfully urge some caution on this court in attaching any weight to the European legislation? That legislation explicitly excludes parents from the category of carers. The 96 Convention could yet do that, but it doesn't at the moment. And the the practical handbook gives some good reasons, we submit, for why it doesn't. But also the Lagarde explanatory report, which we quote in our skeleton at page 10, paragraph 24, in explaining Article 33, one of the matters that is raised as a reason for that provision is the importance for the receiving state essentially to know what's happening, not least from an immigration point of view. And speculating, but it may be that where there is freedom of movement within within Europe, that consideration of immigration is perhaps less important than in circumstances where there is not freedom of movement between the two relevant states. But maybe the circumstances of this case, clearly there needed to be that consultation, and there's nothing really I can add, I don't think, to the submissions that have already been made and to what we set out in our skeleton about where in this case, no doubt with the best will in the world, and today acknowledging the benefit of hindsight, but things went wrong.
Yes, and if we look at, you quoted helpfully from what Lady Justice Black, as she then was, said in VZ 2016 about what I might call it the structured approach which should be taken to obtaining assistance from authorities in another state. As one might expect, it's quite a helpful summary.
Yes, indeed.
And what would one add to that? I was looking through. I mean, Ms. Kavanagh added clarity as to what could be provided. In other words, if there's a specific identified need for some sort of specific services, then it's be sensible to find out whether they can or can't be provided, or what can be provided, and translated at the outset. And those are obviously good if a translation is delayed. The Hague website will indicate what languages requests for information will be acceptable, but so you can check. But if translation is required, clearly, if you're going to be sending documents, they should be translated as she submitted, right at the beginning.
Yes.
Would you add anything else?
Lord,
I know you do at the
end.
You do.
Yes, which of themselves, I don't really consider add to what VZ provides in terms of guidance. It's just, as the court well knows, between around 2014 and 2016-17, there was a flurry of cases dealing with jurisdiction issues, transfer issues, children here from the eastern part of Europe in particular. That understandably has gone quiet, and the focus, of course, now is on the '96 Convention rather than the Brussels regulation in whatever form, and it may well be of assistance. We submit to practitioners for the guidance that we had under the Brussels regulation.
Yes.
With some additions like the translation point to be set out.
Be transposed into the 90.
Yes, indeed, with the renewed focus on.
I'm dealing with your Article 33 submissions. I think the general view is that Article 33 doesn't apply to placement with parents, but does apply to placement with other relatives. But I think the prudent course is always to check with the other relevant authorities to make sure that you're doing what they consider is necessary. So that they can always say no, this is an Article 33, but if they say yes, they will be rather perturbed if Article 33 is not used when, in their view, it should be.
Well, Lord, yes, respectfully, and not least because of the cooperation provisions. If I understand the guidance correctly, Article 33 is the only one that where there is a obligatory consultation between the respective member states. So if the receiving state in question viewed it that way and was not consulted, then there could be all sorts of problems further down the line.
Yeah.
But well, the only other point to add to that, again, it's going back to that paragraph 13.38.
Yes.
Miss Markham very kindly said she was stealing my thunder. I was stealing Miss Kavanagh's thunder because she referred to that in her skeleton. But that paragraph ends with, there is no settled practice on this issue as yet.
That was 2011. There's been another special commission since. But,
right.
Yeah.
Thank you, Lord. Lady, my lords, may I just take a moment? Thank you. Unless there's anything further.
Thank you very much indeed.
Thank you very much.
Any reply, Miss Markham?
Only very shortly on points of clarification. There were a number of points raised about the possible uncertainty of the foster placement. But within both the final submissions of the guardian and the local authority, they confirmed, they called foster care by her first name, they confirmed that she was willing to have both the boys live with her. There's an issue about payment that was dealt with in the submissions, and very clear that notwithstanding any of the issues about 1 room, 2 children, C could remain there long after D left, and also that the placement for the older brother could be there if he went to university. So it was into higher education. That's set out in the final submissions, both of the guardian and the local authority. Equally, in relation to the submissions made by Ms. Kavanagh Casey on behalf of the father, when she submitted, it was incumbent on the local authority to set out the risks. Well, they did do that, both in the final evidence of the social worker, and in particular, apologies, at 323. You have here, and I'm sure that, my lady, my lord, you've had this. You have the realistic options. This is just part of the final evidence. Child C is referred to throughout, but you have there factors in favour, factors against. You have at the end of that statement also the analysis of risk for child C at 328. And that includes not only, and there are the summary 3 bullet points at 328, the limited insight of the father to the concerns, the oral evidence, limited insight into the impact of his mental health, concerns of the father's relationship and ability to promote contact between C and half-siblings, and then an earlier concern about commitment to relationship. But it also goes on in relation to the more complex relationships within the family, and then over the page, of course, that nuance about the foster placement. So the local authority did set it out. It may be brief when we've analysed all the evidence, and certainly in the final written submissions on behalf of the local authority, that and those points are taken again in there at 216. So Ms Kavanagh Case is right to say it was the local authority to set out the risk across not only domestic abuse, but the relationships, the placement, the loss of placement, loss of relationships. But they are there, and they were before the learned judge. And of course, I've already made submission in relation to this. When you look at her judgment, she says, I have read that. I've read the local authority's approach. I've read the Guardian's approach. I come to my own conclusions. But what's lacking is how she factored in what is said by both local authority and the Guardian to come to her conclusions. I think those were the only matters that I wanted to draw my lady my lord's attention to in terms of page references. Additionally, also, we have sent through to the clerk. I'm not sure whose clerk it is. I apologize.
We have it, thank you.
Yes, you have that. So that's the parenting assessment.
We have, thank you. Has everyone else got copies of that?
Yes, maybe it was copied in. In relation to outcome, I made the submissions earlier, the local authority's position. Is there anything else I can assist with?
Thank you very much, Ms Markham. We're going to rise for a few minutes.
And that's as they should be placed. Yeah, send it through. Send it through. Yeah.
If they want brief things.
Absolutely. Yeah. We don't want any missteps.
That was followed his comment. So this is marked as for discussion. But anyway, she needed a clerk for 33.
Okay,
Which was
so it's a
September last year.
genuine reason.
Yeah. Excellent. Yeah.
Julie from a professional parent.
And my bad point.
By my junior, but that's a new
We're about to send something through to the Ladyship and Lordship. Could you just let them know it's coming through to them? Thank you.
What was that, sorry?
There's a special commission paper on the scope of Article 23 from September.
Yes. Oh,
You
right.
probably know.
No, I didn't find it. I think I'd found it after the Scullies had gone in, but with everything I haven't put it forward.
Just if they're going to
Send it
decide
in,
it.
yes.
Yeah.
Copies of it, but the others should have it. Do you want to just copy it?
I'm going to copy it.
Reply. Well, why don't you reply to Leanne's?
You reply to
email,
Leanne's,
which was
exactly.
Lord Justice Moylan just referred to there have been a number of special commissions since, which caused me to check, and there is a special commission report from September of last year dealing specifically with Article 33. So I'm going to send that through. So you sent in on the number of commissions? a
just
special
one.
commission paper from September of last year dealing with the scope of Article 33. Thanks very much.
Could fall within
I'm sure it has,
our
but I think it's helpful.
yeah.
Who's the answer?
So it came at 13.50 with Anne Target, and she copied. Yes, she did copy it.
There's a little look after it. Look over it after the hearing.
Perfect.
All rise if able.
Miss Markham, we're going to allow the appeal. The matter is going to be remitted to the family presider, who I think is Mrs. Justice Knowles.
She is.
So that you all know precisely what's going to happen, I intend to contact her to alert her that a matter will be coming in front of her for urgent case management and allocation.
Thank you.
And in the meantime, there'll be an interim care order and contact will be a matter for the local authority in negotiation with the various parties. I think that is all that we actually need to do at this stage.
Yes.
Obviously, judgment will follow with reasons. I should just emphasise that there's no need for first case management hearing to wait until we've handed down our judgment, because obviously we're very concerned, Ms. Governor, about delay for the purposes of your lay client, and I'd be grateful if you would explain to him that rather complicated arrangement, that he will get his reasons, but the necessity for C and no doubt his desire for matters to progress as quickly as possible will keep the case moving.
Of course. Thank you. I'll make sure that's communicated to him.
Thank you. Also, Ms Sampson, obviously the mother needs to understand that also. Might I ask your junior to have carriage of the order as well?
Thank you, my lady. And I think also for the avoidance of doubt to set aside the child arrangements order.
Yes. Yes, and that contain. And if you could all agree the order, please.
Yes.
Thank you.
Ms Kavanagh.
I will be seeking from the local authority confirmation that the contract will continue as it is pending that hearing, which is monthly at the moment. But if there are any changes, then that ought to be notified, because we may need to make an application.
Yeah, well, that will be a matter for Knowles J.
Yes, there's a stay. The reason I raise it is there is a stay, I understand, on the order until the appeal is complete. The appeal, of course, isn't complete until the judgment's handed down, but it may be that you're lifting the stay today, making the ICO, and the arrangements, therefore, have continued pending appeal.
Yes.
And it's just whether they continue pending your judgment.
Well, I'm sure that you all know each other well enough and are grown up enough to be able to discuss that between you. And that, fortunately, we have Mr. Stoner here for the guardian. So for the guardian, so he can assist you in reaching any agreement if needs be. But I will be contacting Knowles J, if not this afternoon, tomorrow morning, to inform her about that the case is coming her way and to make sure it goes in for case management as quickly as possible.
Thank you very much, my lady.
Is there anything else that we can usefully do?
No, I don't think so. Thank you very much.
No, well, thank you all very much indeed. We're very grateful for all your written submissions and your very helpful and concise submissions on the part of you all. And also for the juniors behind, I know a lot of the work was done by them in the preparation of the skeleton arguments. I'm very grateful. I'm always conscious that there's a lot of work done behind the scenes before the silks swan in. Thank you all very much.
All rise if able.
No, I didn't.